Hello, welcome to Legal Advisors World. My name is Sam Francis, and here we answer your legal questions in the most simplified manner. Today, we will be talking about elements of an offense. This is a continuation of our criminal law series. If you are seeing my face for the first time, I'd like you to subscribe. I'd like you to give this video a thumbs up, like it, share it, drop your comments and questions in the comment section because we love reading from you. And who knows, maybe you can even give suggestions on videos or issues you would like us to talk about. Without further ado, let us jump right into today's video. Yes, did you know that action alone does not constitute guilt? Like, does not make somebody guilty of an offense unless a particular state of mind is present. And that in Latin we say actus non facit reus. Actus non facit reus. Action alone does not make someone guilty of an offense unless a particular state of mind is present. There are two elements of an offense. Before an offense can be said to have been committed, two things must have happened. The first is called the guilty act. Something must have been done, and that is what in Latin is called actus reus, the deed that was done, the act that was done, the guilty act, actus reus. The second element of an offense is called mens rea. Mens rea means the guilty mind. This is talking about the mind. The first, actus reus, is talking about the act, while mens rea is talking about the mind, the guilty act and the guilty mind. Before someone can be held guilty of an offense, the person must both have committed or have done a guilty act with a guilty mind. So an act alone without the mind won't constitute an offense. Having bad intention, having a bad mind without the act may not also constitute an offense. Yes. So before you can say someone has committed an offense or an offense has been committed, these two elements must be present. Now let's zoom in on actus reus. Actus reus, that is, don't forget, the guilty act can be manifested in a number of ways through the deed itself that was done. That is the act itself that the law has prohibited. That is one. Actus reus can also manifest in the circumstance in which the act was done, the manner in which the act was done, or the circumstance in which the act was done. For example, lying is not an offense under Nigerian criminal law, but when you lie on oath, that is an offense, that is perjury. So the circumstance in which the act was done. Another way actus reus can manifest is in the consequence of a conduct, a consequence of an action that has been done. For example, having a motor accident is not an offense under the Nigerian criminal law, but when you are involved in a motor accident and you cause the death of another person, then that is manslaughter. That is an offense. So don't forget, actus reus can manifest in the deed, the act itself that was done, the manner in which the deed was done. Another example for the manner or the circumstance in which the deed was done is the offense of burglary. If an house is broken into between the hours of 6 a.m. and 6 p.m., that constitutes an offense of burglary. And then don't forget the perjury example to lying on oath. And the third way it manifests is the consequence of the conduct, the consequence of the act itself, like manslaughter or murder. You know, when someone does something, the person that is murder. And when it's not done intentionally, then that's manslaughter, which is also called culpable homicide. Culpable homicide. Yes. So that is how actus reus manifest. Another important thing to learn on actus reus is that the conduct must be voluntary. The conduct in which we are accusing this person of committing must be a voluntary conduct. There's the case of Martins against State, in which a drunk man, he was drunk, he was being rowdy, he was arrested by officers, and the officers took him to the highway. It was the officers that took him to the highway. It was not on the highway initially. It was just being rowdy somewhere. And then the officers took him to the highway, and then they charged him with the offense of being rowdy on the highway. The court held in the favor of Martins that Martins being drunk on the highway was not his voluntary conduct. The officers took him there. So he could not be held guilty of being drunk on the highway because he didn't voluntarily go to the highway. He was taken there by the officers themselves. So an action must be voluntary before you can say actus reus is present. Another thing you must note is that it's not only actions that the law criminalizes. In certain circumstances, the law also criminalizes omissions, but not generally. Generally, omissions do not constitute actus reus. But there are circumstances in which an omission can constitute an offense or can constitute actus reus. And those instances include when someone has a legal obligation to do something and the person refuses to do it, then the person can be guilty actually. That omission to do what is legally required to do, can make the person guilty. And this can also manifest in a number of ways. For example, if someone is mandated by statute to do something and he refuses to do it, or if someone is mandated by a legal contractual relationship and he refuses and he omits to do it, for example, you employed a night guard and he was not at his duty post and then something happens to what is supposed to be protecting, then that can constitute actus reus. Even though it was an omission, it can constitute actus reus. When someone voluntarily assumes duty and the person omits to perform the duty, that can also constitute actus reus. Another example of an omission that can constitute actus reus is in the case of special relationships. And when we say special relationships, we're talking about relationships between parents and children, husband and wife, lawyer and client, accountant and client, clergy and client. When there's a special relationship, which almost a fiduciary relationship, which requires that a party conduct themselves bona fide with utmost good faith, and they omit to do their duty, that could also constitute actus reus. So what have you learned from this video? Before an offense can happen or can be said to be in existence, there must be actus reus and mens rea. Actus reus is the guilty act, mens rea is the guilty mind. But this video, we spoke more about actus reus because in the next one, we will talk about mens rea by the grace of God. And then we learned that the action must be voluntary and omission can also constitute actus reus. I hope you have learned one or two things from this video. Please don't forget to subscribe, like, and share. I call you blessed.